Welcome back, ladies and gentlemen, to another episode of Lassiter Law. I am here with my co-host, Lacey Gee.
And I am here with the very talented, the very smart, the very informative Mark Lassiter. Mark Lassiter, what are we discussing today?
Today, we're going to talk about something that we talked about briefly in episode 2, I believe, which was what to expect from a DWI, but there's a certain case that just had a result posted, and so it's very important for the clients out there, the people, you, the individual, and the attorneys that we're talking to know what the ramifications of this case are. So today, we are going to talk about discovery.
So this is a case that just happened that has changed the law since I last saw you.
Actually, the case had already been appellate decision. So just to give everybody kind of a background, when you have a case, right, that comes out, it's always from an appeal. So if you have somebody that's referring to case law, what they're referring to is an event, a trial that happened either, and sometimes it's prior to trial, but there was a resolution. If you're a defendant, you have to have a resolution or a disposition to your case before you can appeal. And if you're the state, you can actually appeal it based on a pretrial decision by a judge. So in cases in which there are appeals, appellate judges get together and they just say, this is the law. And then if you don't like that, you can go to the highest court in the state of Texas for criminal, which is the Court of Criminal Appeals. And they had a case that was petitioned to them. So Court of Appeals decides an issue. Then what happens is the Court of Criminal Appeals took that up on what's called a petition for discretionary review and decided I say in somebody's favor, but they decided what the law is regarding discovery in criminal cases. And then the prosecutors, the state of Texas, decided, we don't like your decision, Court of Criminal Appeals. Please look at it again. And today they denied the opportunity for them to be heard on that because they said, we made the right decision the first time.
Okay.
So that's what we're going to talk about. So the case is a case called Heath. And in Heath, what had happened is the prosecution failed to turn over a key piece of evidence. That key piece of evidence being a 911 call.
So this is a criminal case.
It is a criminal case.
Are you going to tell me what it's regarding? Are we getting there?
No, we're not really getting there because the facts of the case are not really relevant to discovery discussions.
Okay.
Like we can go into every appellate decision and say, this is why they did it right, this is why they did it wrong. But really what we concentrate on is the decision and the ramifications of that decision. So lawyers out there, if you're looking at an appellate case and you're trying to use case law to support your position for your argument, whatever the case may be, always take a brief look at the facts, but then look at the opinion and extrapolate what you can, because your facts are never going to be the same as the decision or the facts of that appellate case. They're going to be similar in certain regards, and you want to emphasize those points, but you want to be able to do is pull, this is the rule of law. And in fact, law students, because we want to make sure the law students understand what to do as well, you need to be able to, this is what lawyers do, pull the important point out of an appellate decision. So in any case that you're looking at, you need to be able to determine this is the actual decision and then how to apply that to your case or other cases.
Question. Is there only one right answer about what it is that you should be pulling from that case, or is it case by case, or sometimes do you have to get creative? Like, is there one answer that's glaring and that's why this happened?
Well, I'd love to say that it's that simple. It's like, hey, the appellate court determined this. This is what we call a bright line rule of law. So bright line rules are the Court of Appeals spells out, this is the law, this is how you should interpret it. That is rarely, if ever, done. I mean, rarely. Most of the time, the Court of Appeals and the Court of Criminal Appeals decide a very nuanced issue, and it's up to you, the lawyer, to be able to pull the decision that they made, the opinion, pull the rule that they decided that this should be followed. This is the rule of law that we're going to follow, and then apply it to your case facts. And so you have to be able to know what they're saying. And the funny part is, many people looking at these same decisions, the same words, will interpret it differently.
Because your job is a lot creative of how you can come up with an answer. Even though it's the law, you still have to find creative and practical applications to be able to get to that answer, correct?
It's the application. So we always talk about practical application here. It is the practical application of the law to your facts. How do you tie those together? How do you see that these facts are emblematic of this rule of law, and therefore this is the result, or this should be the result when you're arguing to a judge or to a jury for that matter. So when we talk about discovery, which is what Heath was about, Heath discussed whether or not when the state fails to disclose evidence to the defense. So in that case, it was a 911 call. So imagine you're the defendant. In the middle of trial, they come out and they say, Judge, we want to introduce this piece of evidence, this 911 call that, in our opinion, has evidence that proves the defendant is guilty. But we forgot to give it to the defense prior to trial. And the jury has been sworn in. Remember, we talked about that in the last episode, the importance of swearing in a jury because it establishes jeopardy. So now the judge is left with the decision, what do I do? Let me ask you, Lacey, I want you to pretend that you're the judge, right? If you were the judge and you heard that there is a discovery obligation. Now, keep in mind, ladies and gentlemen, you must request discovery in writing. An oral request is insufficient. The law under 3914 of the Texas Code of Criminal Procedure mandates that you make a timely request that is in writing. So what I would do, and we do in all of our cases, is we quote the language of the statute, 3914. We quote it directly in a letter of representation and in a motion. And we say, and it's not a motion, actually, it's a request. So we title it as a request. And this matters because a court of appeals has decided if you title something as a motion, it must be ruled on. If you title it as a request, it does not need a ruling. So we title our request for discovery as just that, and we quote the language, give us everything that you have. But getting back to Heath, you're the judge, Lacey. We made our timely request, as we should, in writing. We prepared for trial. We got to a trial, we swore in a jury, and there is a piece of evidence that you now are hearing that the state of Texas, the prosecutors, want to introduce against the defendant. And I, the defense lawyer, raised my hand and said, Judge, I have an objection. That evidence was never disclosed to us prior to today. What do you think would be fair for you, the judge, knowing that you cannot simply dismiss the jury because that will lead to a whole host of problems on prosecutorial misconduct and double jeopardy concerns? What would you do if you had to rule on whether or not that evidence is admissible or inadmissible?
I'm going to use regular people language because I don't know how.
That's what you should do.
Like a judge, but it's obviously unfair if it's something that's crucial to the case that was not disclosed beforehand, because you have to do your job of checking and making sure that everything was done. I don't know how to avoid dismissing or double jeopardy, but that does not sound fair to the defendant or to yourself.
That's exactly right. So when I went to law school, when I didn't know the answer, I evaluated it just like you did. And I said, what is fair? What would be a just outcome? And then I based my essay answer on that, because law is designed to be that, ladies and gentlemen. It's designed to be fair. That's the whole point of the law. The judges are supposed to be fair and impartial. Fair is throughout the course of the law. It is always supposed to be fair. Even though I always say to my kids, life's not fair, deal with it. The law is supposed to be, no matter what. It's not supposed to take sides.
And that's why everyone has the right to a criminal defense, which is something that we discussed last week.
That's exactly right. Everybody has a right to an attorney. Now, you don't have a right to a good attorney if you can't afford one. But that's why we want to be able to afford for attorneys. You have a fund stashed away for a rainy day, just in case something happens. But in this case, going back to it, the decision was fair that they cannot use that evidence. And that's what the judge decided. They said hey, you didn't give it to the defense prior to trial after they had already requested that particular piece of evidence. So the judge in Heath determined we are not going to allow that evidence to go in front of a jury. Even though that evidence existed, and even though it had been in existence for a long amount of time, the prosecutor's excuse of, well, we didn't get it from the police department until that day, that's not a good enough excuse. And Heath, the court decided that the police departments and the agencies that work for the police, and this is where it's important, are arms of the government. They are arms of the state, which means that if one of them make a mistake, it applies to all of them. So it doesn't matter if the prosecutor didn't know that that evidence existed because the police department didn't give it to them. It doesn't matter if the prosecutor didn't have the evidence in hand to give it. It is their responsibility to seek it out and to provide it if it was requested. And so because that didn't happen, the Heath court said, it's out, you can't use it. Now the prosecutor asked the judge, can we stop the proceedings and allow me to appeal? And the judge did. He allowed them, which is rare.
So that means
the trial is over and the state gets to appeal that discovery issue, that specific issue.
So then in return, they reevaluate to see if it can be used, but then you would also have the information as well.
Well, now you've got the information, right? So when you retry the case, if that happens to be what happens, then that information is going to be there because you have it now.
Okay. In
a time, well before trial. Mm-hmm. But the important part of Heath is not that. The important part of Heath is when they appealed on two parts, saying, hey, we shouldn't be held accountable for something a police department does, and exclusion is not the proper remedy. And what the Court of Criminal Appeals and Court of Appeals said is exclusion is within the discretion of the judge. So whatever judge that you're talking to, whatever judge the attorney is representing you on, that attorney needs to be able to make the argument that they made in Heath, which is, and keep in mind, they should have been making this argument long ago. I've been making it for 20 years. Mm-hmm. But now you have a case that directly backs it up. And the court said in Heath, the judge has discretion to exclude evidence because they have the right to the right remedy. They have the right to decide what the right remedy for not providing that evidence is. And they also directly held that the arms of the government are all part of the government. They're all part of the state of Texas. So the evidence could be properly excluded, which is what happened in our previous case that we had talked about in practical application. The evidence was excluded. Therefore, the state had no evidence to proceed on that particular matter. So that's why it's important. That's why we do discovery. And that's why if you have an attorney that knows what they're doing, they should be writing a written request that should go in at the very beginning of the case. They should not wait until the case is set for trial to do these types of requests. Because if you don't do the request, then you don't have the information that you need as an attorney, and you don't have the information as the citizen, as the client, to even evaluate whether you should go to trial or not. Mm-hmm. And you probably should know what the evidence is going to be against you before you decide whether or not you want to go to trial. Mm-hmm. I mean, can you imagine, Lacey, if you were there with me as my client, I bring you in and I said, this is the evidence. And you're like, okay, well, that doesn't seem so bad. And I'm like, it's not. Let's go to trial. And then we find out later that there's more evidence that directly proves that you did something that you knew about. And you're like, well, they don't have it, so we're going to be okay in the trial. Then you find out later on that they have it because they didn't provide it.
Because your answer and your suggestion could have changed based on
That's right. Evidence. And then my advice is based on inaccurate information, which is unfair to you, the citizen. So when I walk everybody through discovery and how to do it, I want you to keep in mind that your lawyer should always, always, always go over your discovery with you. I have heard horror stories, countless horror stories from clients that had former attorneys. And what they tell me is, my attorney, they don't know any of the facts. I remember I had this one guy who came in and he told me, I'm set for trial. I need a new attorney and I don't trust my attorney. And I went, okay, but what are the facts of your case? And he tries to tell me, and I was like, no, you're misunderstanding. Tell me what the facts of the case are from the prosecution perspective. Like, what evidence do they have against you? And he said, I don't know. I said, what do you mean you don't know? You're set for trial. I was like, your attorney has not gone over the evidence with you? He said, no. I said, do you know what the video shows? He goes, no.
He didn't properly screen his attorney, which is a previous episode that we covered.
That's correct. Mm-hmm. So he had a bad lawyer. He was right to switch. He ended up switching. We got the evidence. We reviewed it for the first, he'd seen, his case was 3 years old and he was seeing it for the first time. Now, attorneys always, always, always review the evidence with your client so that they know what they're up against, so that they know when you make a recommendation, why you make that recommendation. It's not enough for you to make it. It's not enough to say, trust me.
And clients also need to be forthcoming with all of the information, even if it's possibly something that hasn't been discovered. But if it's your client, you tell your attorney everything. This isn't the judgment zone. Tell them what they're facing so they wouldn't be blindsided. I guess you can't be blindsided in court, but you still have to be honest with your attorney and give all the facts so you know what you're looking for or looking at.
Well, you certainly can be. And that brings up an interesting point is, what do you tell your lawyer, right? Let's start with what should happen, right? And we'll get to that answer to that question in just a minute. So I want to be clear on what should happen first, and then we'll get to all the questions that happen because you've done what you should do. So first, you make a timely request, right? Once you get the evidence, in most of the counties, you're going to get that online. So most of the counties have some sort of portal that the attorney can register for, and then they provide the evidence. So it's almost instantaneous. So within the first setting between the indictment or the information, the attorney should have the information. So you as the client need to know that your attorney has the information almost from day one, right? From the first time that you have to appear in court. You should be requesting as the client a time for you to come in and view that evidence with them. And the attorney, you should be telling your client, we need to schedule a time to review it. So let's say that all has happened. You've gotten the discovery. Discovery is not always complete. But you, as the attorney, will not know that until you review it with the client. So going back to what should the client tell the attorney? The attorney, the important thing for him is what can they prove? Not whether you did it or not. That has no bearing. It is, can they prove it? So you look at it from the perspective of, here is the state's evidence, can they prove it? You look at it I always do it with the client there so they see my first reaction. When I look at a video, we look at it together and I say, let's pretend that we're the jury and we're seeing it for the first time. What would we think? And then based upon the evidence, I will ask the client questions. Is this true? Is this true? What is missing? Is there something out there that could help us? That is when you, as the client, have the responsibility to tell your lawyer, this is what happened. No, this isn't on video, but this is what happened. Many times, my clients will tell me outside of the video ended, and they said, we were in the back of the police car, and the officer said, hey, yeah, I'm just doing this because my supervisor told me to. I think you're fine. Those are important details that I would never know, so you as the client have to tell me. But answering your question, do you as the client need to come out and say, this is everything that happened and I'm guilty? No. You need to tell me what happened and you need to answer the questions that I have, but you do not need to tell me if you are guilty or not, because that is not what we are there for. Like I said, we're not there to get you dismissals. We're not there to get you not guilties. We are there to get you the best possible result. And that result may be a plea because we want to avoid risk. It may be a trial because the risk doesn't outweigh the reward of getting a not guilty. And it may be pursuing a dismissal because irrespective of the fact, let's just use drugs, that you had 1,000 pounds of drugs in your trunk. If they didn't detain you correctly, then those 1,000 pounds of drugs are not admissible, and I should be able to obtain a dismissal for you. So guilt rarely plays a factor when I'm evaluating a case. It is only can they prove it. Did they do their job correctly, the police? So does that answer your question, Lacey, of telling me everything?
Yes. I wasn't even thinking about guilty or not guilty. I was thinking, this is what happened at the time. This is how much I had to drink, how many drugs I had on me, whatever the case may be.
That you should tell your lawyer. So if we're going to focus in on DWI here because this is the topic that we're talking about now, but it applies to all different types of crimes. Yes, tell your lawyer what happened so that he can evaluate what's missing. Because let's say in a DWI case, you tell me, Mark, I had 3 drinks, but I also had a lot of drugs. Like I had a smorgasbord of drugs. Plus I'm hypothetical. Plus I'm on Xanax, which is prescribed, and all of these different things would say don't combine with alcohol, right? I need to know that because if they come out with a blood test and it's low, let's say it's under a 0.08, I need to know that if I push too hard, they have the blood. They can just send it off for retesting for drugs. And if they send it off for testing on drugs, I need to know that there might be a huge effect on what we can do with the case once they find out that you have 11 different drugs in your system, right? So I need to know that when I'm going in and negotiating what I think is a fair result, because I don't want them to go out and go, oh, you want to go to trial? Well, we'll just test the blood. Even though they didn't do it the first time, they may do it in preparation for trial. I've got to have that in the back of my mind, which I wouldn't know unless you tell me. And yes, ladies and gentlemen, there is attorney-client privilege for everything that you tell your lawyer, except if you're asking him how to commit a crime. The lawyer can never, there is no attorney-client privilege for the lawyer telling you how to commit a crime. And I'll give you a perfect example.
I was about to ask if that's happened before.
It has. So if somebody comes into my office and they say, hey, we want to get drugs or we want to drive drunk, how do you do it and get away with it? I always tell them, I cannot tell you how to commit a crime. That is against the law. I would have no attorney-client privilege in that respect, in that conversation.
Mm-hmm.
In other words, they can ask the client to testify, did he tell you how to break the law? What you can do is tell them what the law is. And so I always advise, look, I can't tell you how to break it. What I can tell you is what is the search and seizure law. This is what they need in order to search. This is what they need in order to detain. But that is also written out in the Fourth Amendment, right? Search and seizure. I'm explaining the cases that have described in this situation, this is an okay detention. In this situation, they can search your vehicle, whatever. But I'm not going to tell you, I would do this, even if I know how the law could be broken and you would get away with it. I cannot tell you because I'm not supposed to be out there advising criminals on how to be better criminals.
Mark Lassiter says, don't smoke weed in your car because that smell does not go away. I don't think that you're recommending to people how to smuggle drugs.
That's exactly right. I say, don't smoke weed in your car because that's a crime and that's pretty stupid, right? Especially when you're going to leave a residue, because I'm describing to you why they would have the right to search. A residue that just reeks forever. I mean, it just seems to never go away. And in fact, I was in a hearing yesterday with a judge, and we discussed something very interesting, which is the potency of marijuana. In fact, I should probably bring the judge on here to discuss it. So back when you and I were growing up, not that we're old, marijuana was akin to what we know now as hemp, which is it had like a 3%. Like if you ever drink alcohol, it'll say on there 4% alcohol or 10% alcohol. It better not be 10%, but 6, 7, some of the bigger lagers, right? The homemade brews. The moonshines are like your 15% alcohol, right? Then you see the 40% alcohol by content and the mixed drinks, right? And the liquors. If you have a potency back in our day and you got high and it was like a 3% potency rate, right? Meaning for the most part, it only has about 3% of the actual hallucinogenic.
But it also wasn't regulated then because that was the homegrown stuff.
That's the stuff nobody really had the good stuff. And when you had the good stuff, you kept that dealer. Not that we had dealers. But now they've done tests that the marijuana potency level is like 14%. Now, the studies that we did on whether or not marijuana had an effect on somebody, like in their brains, their everyday life going forward, does their brain develop, what happens? Those were all done based on a potency rate of like 3%, like 4 or 5% at worst. Now we're talking 14%. So the young people of today, you need to be aware, if you smoke marijuana, you are risking some really bad health concerns. And I'm not here to judge you if you believe marijuana should be legal, whatever your feelings are. We are not here to tell you that those feelings are incorrect. You're entitled to those feelings, but you need to have informed opinions. And that's what we lack throughout the country. We lack the ability to form an informed opinion because we rely on somebody else's research. Let me ask you, Lacey, and not to get too much into your personal life, do you have a religion that you aspire or prescribe to? Were you brought up on one?
Yes.
Christian? Mm-hmm. Okay. When you went to church and the pastor told you this is what happened, did you ever go double check his work?
No. I've read the Bible, not the whole thing, but
okay,
no.
Fair. Because you were in church and when we read passages of the Bible, let me ask you, did you ever go back and see if the translation that you were reading was an accurate translation?
No. King Edwards or King
James. Yeah, King James Version. That's what everybody says.
Intense.
Not exactly. That's a man-made translation, right? Mm-hmm. In the 1600s. So when we think about things, it's fair to say that you based your entire growing up religious years on stuff that somebody else told you was true. What do we not do as jurors? What have I talked about as a juror you're not supposed to do? You're not supposed to make what? Assumption. That's exactly right. Assumptions. See, I know I've been teaching something here.
You have. You have. I've both enjoyed it and learned a lot.
So if we as jurors, our literal one job is not to accept assumptions. We must be proven something is true. If a pastor tells you, hey, this is true, I don't care what religion it is, and they say, go back and look at this book. Okay, you looked at the book. What makes the book true? You need to do an evaluation, and I would encourage everyone to do. I had to do this. I was homeschooled and raised in a very religious organization. Some might even call it a cult to certain extents because of the amount of religion and the practice and the way in which things were done and the rules that they enforced. But all of this to say is, it forced me to think, wait, they're telling me these things that I can't do this and I can't do this and I can't do, because the Bible says it. And I said, I've looked at the Bible and it doesn't say that. That's your interpretation. So I went back and said, wait a minute, is the Bible even true? So I did an analysis. It took years. I went back and looked at the books. And let me ask you something. How do you know if something is true or not? How would you evaluate that? Because we're talking about a Bible that was written at the turn of BC versus AD. Most people don't want to accept this, but that is before Christ and after death. They've named it something else, but that is not what it is. It is literal before Christ, after death. Our entire calendar is based on, they want to call it something else now. Go back and look at the people that had invented the calendar. It is Catholic priests, and they said before Christ, after death. Let's use the right terms. So if you were to evaluate something that was written thousands of years ago, we're talking about Moses, we're talking about literally like 5,500 years ago, maybe 5,000 years ago, something like that. How would you do it?
Based on research and facts would be the only thing I can think of.
Most people don't even know this, even though they should teach it in school. It drives me crazy. I talk about it to juries. That's why I'm tying it in here. It's called the historical method. You ever heard of this?
No.
The historical method uses a series of things to check the accuracy of an ancient document. So, for instance, it looks at, do the people in this book that it claims to exist, did they exist? Well, there's proof of their existence, of the people that we talk about in the Bible, the kings, the old kings like King David, King Solomon. There's proof in other cultures of their existence. Okay, how about architecturally? In archaeology, do the places that they talk about exist? And where they say they existed? There was this big thing that we could prove the Bible is not true because the Hittite Empire that they claim existed is not there. For 100 years, when we were trying to prove at the time that Bible wasn't true, that scholars were trying to do that, they kept pointing to the Hittite Empire saying, they don't exist, the Bible's not true. Well, guess what they found? They found existence of the Hittite Empire. They're like, that shouldn't exist. And like, oh, crap, right? Bibles, archaeology has been proven over and over and over again. This is not to convince you, ladies and gentlemen. I'm saying do your own research. Then they look at the author. Who is the author and what prejudices or what biases did that person have? Now, the Bible is written by 27 or something like that, different authors. It's interesting that most of them have the exact same story for events that happened when they weren't around, right? And then there's nothing to refute those things. In fact, there's plenty, if you go back to, let's say, the time of Jesus, there's plenty of evidence to suggest that a Christ figure existed. So the figure existed, right? And then another method, or another factor of this historical method, do other ancient texts reference the Bible? Well, guess what? They do. So we look at these things, and then only you, the individual, can determine what you believe to be true or not, what you believe to be fact or fiction. What I encourage all of you to do is in anything, not just religion, not just in jury trials, if someone is telling you something is true, you need to research it for yourself so that you can justify why you believe it to be true. And that means politically too, ladies and gentlemen. Don't just take Twitter and go, hey, somebody on Twitter said it's true. You can take bites, you can take partials. That is why I can tie this all into today's topic of discovery. Because if you don't have all the discovery, you can't make a factual and informed determination. You've got to be able to do that, because if you don't make an informed decision, what are we basing our decision on, Lacey?
Guesswork.
Assumptions. We can't do it. We can't fill in those gaps. If you want to say something is fact, you better know that it's a fact. So ladies and gentlemen, when you're on a jury or you're one of my clients, one of the things that I will emphasize is what is fact and what is faith. And it's okay to have faith, but it's not okay to say faith is a fact.
What was the determination from this case? What has changed because of what happened at this case?
So all going back to this Heath case, Court of Criminal Appeals, one of the major decisions that they made, or major opinions that they wrote in this case, was that a prosecutor that has a timely request that fails to abide by it, fails to go out and look for that evidence, right? It is akin to having a willful conduct. Now, why does that matter? Ladies and gentlemen, willful conduct is a basis for double jeopardy dismissal, or granting a double jeopardy request. So if in this trial, let's say in the Heath trial, it happened exactly as they did, the 911 call came in late, the judge excluded it, and the judge granted a continuance at the request of the prosecutor. You can then go back and say, we want a double jeopardy dismissal, which means it can never be brought again because willful conduct caused what's known as a mistrial. A mistrial is what happens after jeopardy has attached. So this is more for the lawyers out there. When you have jeopardy, again, you have jeopardy if a jury has been sworn in or in a trial before the court, the first witness has testified. Just the start of their testimony, that is when jeopardy attaches. So when jeopardy attaches and there is a continuance request because somebody in the state, from the state, did not do something properly. Let's just say in this case, they failed to provide evidence that they should have provided. Then the judge grants that, but before they grant a continuance, they must dismiss a jury, and the only way to do so is a mistrial, and they must give a reason for the mistrial. In this case, the reason for the mistrial would be the conduct of the state in failing to provide the evidence. If that conduct is deemed to be willful under the Supreme Court, you now have a valid claim for double jeopardy. So the Court of Criminal Appeals in Heath said failing negligence, which is what this is, you just didn't do your job, negligence can be held to be akin or the same as willful conduct. And that's where it matters. Those words, and that's where as an attorney, you have to be able to look at a case and pull out that opinion, because that statement that negligence is akin to willful conduct is the decision of the case. They decided the judge can exclude conduct if they want to. They decided the police officers are the same as the state of Texas for the purposes of discovery, and negligence, not looking into it, can be considered willful conduct. If you can pull that out of that case of 30 pages of reading, you have done your job, and now you apply it to each and every case so that when you, the attorney, or me in the last case that we talked about, made a timely request, showed the timely request to the court that it had been properly given, that the state had notice of it, and they failed to provide the discovery, you now have a claim if it gets reset and a mistrial happens for double jeopardy for willful conduct. And you can make the argument that not providing the discovery was the willful conduct that caused the mistrial. You've got to know how to win by the details. Only and always attention to detail when evaluating your case. And you, the client, when you're reviewing your discovery with your lawyer, if the lawyer doesn't have you there to review it with, do they necessarily have all of the details that they need to evaluate their case properly?
No, they don't have all the details, and the client is also not prepared.
What we can conclude here is if you don't meet with your lawyer to review the discovery, and I understand that many of you don't want to relive the events, and that's fine, but you're giving up a chance to find something that could lead to winning the case. So if you don't meet with your client, you're not giving the details that they may need, and you're trusting that the state has given you all the information. And you won't know the answer to that unless you were there, because the attorney was not there that night, day, whatever. You've got to be there so you can fill in the gaps for them. Otherwise, you're going into battle with potentially inaccurate information, which we don't want to do.
Mm-hmm. Now, I know the answer to this, and this is something that we're going to cover in a future episode, but you yourself has had laws changed because of how hard you fought for convictions and what is right, that you've had laws changed yourself.
So we've had policies that have changed, and in fact, have many laws. So every time that you take a case on appeal, and attorneys, if you're not willing to appeal the judges, that's fine. But make sure that you send it to an attorney that is, because if they make a decision that's incorrect, that affects a client negatively, and you just let it sit there, then it's going to happen again and again and again. And it goes back to speaking out. When is the right time to speak out? The law has a process for doing so. Now, it does take money, but When you do that, which is considered the appeal, case law is generated. Every appeal has to have an opinion, a decision rendered by the Court of Appeals. That decision is considered case law. So you are, in effect, creating law. Now, it may be good for you, it may not. The judges don't always have to see eye to eye. And I'll give you a perfect example of how we created a situation that was followed by courts of appeals across the country. We had a case, it was a DWI case, where a gentleman was parked in a parking lot. They were in a parking spot, legally parked in an empty parking lot. And the officer had been through that area, saw the car there, went ahead and went around the block, saw the car still there, and came up behind the car in the empty parking lot, shined a spotlight on them as they were backing out. So once the car saw the police officer enter the parking lot, they begin to back out slowly. The police officer gets right behind them and shines their spotlight, not their red and blues, indicating a detention, but just the spotlight. The person responded to that spotlight, thinking that they needed to talk to the police officer. That's what the police officer wanted. Pulled back into this parking space and rolled down their window. The officer then approached, smelled the odor of an alcoholic beverage, brought them out. It ended up being a DWI second offense. They arrested them for DWI after failing the field sobriety test. They provided a blood score that was more than triple the legal limit. And I did not get this case. Another attorney got the case. I got a call from that attorney saying, these are bad facts. I can't win. I've heard you can win crazy cases. This one's yours. So we talked to the client. He ended up hiring us. And you know what we did? We ended up winning the case. But the way in which we won is how it's very relevant to the discovery and the appellate discussions that we're having today. Because the way in which we won is, first, we challenged the detention. And we'll do a whole segment on search and seizure, but we challenged the detention on the basis that that was in fact a detention. Because if I voluntarily encounter you, in other words, if I'm walking down the street and I'm a police officer and you're Lacey and I say, hey, Lacey, give me your ID. The Court of Criminal Appeals has determined that's not a detention. Even though it seems like a detention, you feel like you don't have the right to just walk away. The Court of Criminal Appeals says you've done nothing wrong. You can say, no, I'm not going to give it to you, and continue walking. Then if he puts a hand on you or something else, that's a detention. So what the prosecutor argued was this spotlight was not a detention. It was what's called a voluntary encounter. Now, we disproved that. And the way in which we disproved that is the law states that it is from the mind of the individual. So you, Lacey, would you have felt free to leave if you were trying to drive away and a police officer in a marked squad car in a well-lit parking lot at a 2 a.m. in the evening or early morning hours shines a spotlight on you? Do you feel like you have to stop and talk to them?
Yes, I would.
And that's why everybody felt. And the way in which, when we appealed, by the way, we did this in a motion to suppress. We lost the motion to suppress. The judge says, I don't buy it. I'm not granting that. I think it's a voluntary encounter. And even if it's not a voluntary encounter, they have the right to check on somebody to see if they're okay. And even if it's not a community caretaking, which is the right to check on, see if somebody's okay, they had reasonable suspicion based on burglaries that had happened in the area. We appealed. When we appealed, I asked the judges in oral argument, would any one of you felt free to leave in that scenario? None of them did. I was like, that is the definition of a detention, if you don't feel free to leave as the citizen. And then I established that in order for it to be community caretaking, which is checking on the welfare of someone, you have to have a reasonable belief that person is in need of your assistance. The officer didn't have any information to indicate that person's in need of assistance because they were about to drive away. They weren't flagging them down. There's no hazard lights. If the person had remained in that spot and had not moved when the officer was driving up, then they would have had an argument. And I also established by cross-examining the officer that he was more concerned about the burglaries. But here's where being a good lawyer comes into play. When he told me about the burglaries, I said, officer, describe the most recent burglary. He couldn't. Describe how many burglaries have happened in this area in the last 12 months. He couldn't, because they don't come to court knowing this. It's a ploy. If an officer comes in and says it's a high crime area, well, I said, what makes it a high crime area? As compared to what? Dallas County? What place, and this was in Denton, what place in Dallas County has the highest crime? I don't know. What place in Denton has the highest crime? I don't know. Well, what makes this more high crime than my neighborhood? I don't know. Well, if you don't know any of those things, then you don't have a reasonable suspicion that this was a person about to burglarize someone, especially since they weren't near the area. So we won the appeal. That case was then thrown out, saying this should have been granted. And that changed the law, and everybody now looks to that law and says, hey, this is what, and I say law, not the statute, the case interpreting the statute says you have to do these things. A person sitting in a car with a spotlight behind them under those circumstances would never feel free to leave. That is a decision that you can then use as an attorney in future cases. So when we appeal cases, it is so that across the board, this whole state of Texas, now we can look at this case and say, these judges determined that this is the way you should interpret these sets of facts.
Also, does it matter that he wasn't driving? I mean, he did.
He was driving because he was backing out.
Okay.
But he wasn't driving at first. So let's just say the car was off and they pulled up. Now you're talking about an operation issue, right? Which we can go into in a different segment, but operation is the functioning of something within the vehicle, right? The problem is that prosecutors tend to think that you sitting inside the front seat with the car on is operating the vehicle. And I can disprove that with one easy statement. I said, okay, well then by definition, being inside a car that is running is operating, correct? They're like, yeah. I was like, so is a baby operating the vehicle by being in a car seat? Well, no, that would be ridiculous. Similarly, officer, this is ridiculous.
Because that's all I was thinking was perhaps this person was sitting in the car realizing that they should not be driving.
And that happens a lot.
Mm-hmm.
We have a case right now where the person pulled over on the side of the road because they felt that they had had too much to drink. They were feeling the effects, and they had called for a driver to come pick them up. The driver was actually on scene when the police arrived. And then the police used community caretaking, saying they were concerned with their welfare to justify the stop, then arrested them for DWI. That's not what we're supposed to do. The person did what we as a society would want them to do, and it doesn't matter that when you tested them, they were drunk. What matters is at the time of driving, can you prove that they were intoxicated? So we'll illustrate all of what that person did to the jury, because the DA is not going to give us a deal that's worth taking. And then we will emphasize this person did what we as a society want people to do, which doesn't really have any relevance for whether or not they're intoxicated. But it shows the jury can then trust, they have a reason to trust that person when we say, and a reason to trust me when I say, I understand that they were intoxicated when they were found, but nobody knows when they stopped the vehicle. And the question is, in what state was the person when they stopped the vehicle? Because like we said, operation doesn't apply here. Just because the car is on does not mean they're operating. Yes, it means they operated at some point, but what point was that, and in what state were they in? Nobody knows, because nobody was there when they stopped. So that is the point that we try and make to the jury, and then they're going to be more inclined to listen to us because the person did what we would want them to do as a society. Kind of going off topic there a little bit, talking about operation, but going back to discovery, this is why the discovery matters. Because that person then could give me their phone, which then I could use as evidence to prove in a trial that they had ordered an Uber at X time. And then I can ask the officer, at this time, what state were they in? I don't know. And then you win. So all of this coming back to discovery is the single most important pre-trial thing that you can do. And you need to learn to evaluate that discovery. You need to learn to issue spot. So interns out there, when I trained my intern, the first thing I did was teach her to look for certain issues. Whenever a police officer writes a report, they're supposed to be writing down exactly what happened, right? And justifying why they arrested someone or why they believe they should arrest someone, right? You need to be able to see when it says, I approached the vehicle, you need to know, was that approach a voluntary encounter? Was it under the premise this was a detention because the red and blue lights were on? What kind of approach was this? You got to see the issue. So interns learn issue spotting. In fact, in law school, it may be the most important thing that you can take from law school is how to read a case and spot the issue so that you can then apply any set of facts to that decision. And similarly, you can spot the issue in a set of facts. So issue spotting and discovery. And we'll do another episode on discovery talking about how to spot the issue. But today's episode, what you need to take from it is you have to do a written request. You need to do that timely, as soon as practicable. I mean, literally as soon as you can. The discovery has to be provided to you as soon as practicable. And if they do not provide it until a late date, you can then potentially exclude that evidence. And attorneys and clients review your evidence together.
And also swear in your jury, which is something that we've discussed in a previous episode.
If you want to get the right result, in other words, you want to force the judge to make a decision, because it's easy outside of this, just grant a continuance. The jury's not sworn in. Once you swear the jury in, now the difficult decision comes. How are they going to give a continuance without declaring a mistrial that indicates willful conduct, negligence on the part of the state?
Can I ask you a personal question?
Sure.
What made you decide to become a criminal defense attorney? Because I guess my question is, whenever you go to law school, is it general law studies and then you decide where to go from there?
It's an excellent question. And the answer is most people don't decide what area of law is until they get hired. Because most guys and gals in law school, they're just looking for a job, right? And jobs are kind of scarce right now. So when you come out, what you're looking for is a place that you can call home, and then you kind of morph from there. And most of the people stick with the area that they started. Some switch. Mine was actually an interesting story. I was going to be a insurance defense lawyer. I was hired on by a big firm, but because of some things that happened, they were not able to keep me on. So instead of making big firm money, I then had to look for another job. And I was going to get hired on at this medical malpractice firm, which is kind of a dead area of law in Texas because of tort reform. But I actually negotiated myself out of the job. I had the job. We had an agreed salary, but I was negotiating for some extra things to come in, like paying for the bar exam and moving costs and some other things. And finally they got tired of it and they said, we're done. We're not going to hire you. Blessing in disguise. They pulled their offer because my backup offer was the Dallas District Attorney's office. And so I called them up. I said, guess what? I'm free. I'm coming. And they said, come on. And then I started, right? So I started in the criminal world. I was a prosecutor. And then after that, I switched over to the defense side because I knew criminal law. Mm-hmm. Now, if I had to do it all over again, I probably would have been a plaintiff's lawyer doing personal injury, that type of thing. Because my skill set lies in a trial. So that happens to be either talking to people for a civil matter or for a criminal. It makes no difference to me. In fact, I've done civil trials for civil lawyers. Because of the skill set of being in trial, they are able to see this person is effective with juries. It doesn't matter what the facts are. So you get hired for those types of cases. So it just translated to criminal was the easy transition from what I knew. And then we built a book of business. And as we continued to be successful and the clients continued to see that the attention to detail mattered to me and the results mattered to me, and that all of them were treated like family, they told their friends and they told their friends. And most of my business is referral. They come from people that I've either represented in the past or they know someone that I have represented in the past.
And like you said, you've had other attorneys tell you, I can't get this case. I can't figure it out. You take it. And
Right.
There is a reason why people turn to you whenever they can't figure it out?
They need to do a little attention to detail, and they see that we get these results and they don't know how. And I always tell them the same thing. It's attention to detail.
Incredible. Mark Lassiter, how do people get a hold of you?
You can reach me at 214-845-7007, or you can reach us at www.lomtl.com. Thank you, ladies and gentlemen. That concludes another episode of Lassiter Law.
And I have learned so much. Thank you, Mark Lassiter.
ProPod Digital.